So, here's something most Virginians don't realize. A federal judge in Richmond just relied on a law written after the Civil War to challenge how Virginia strips voting rights today, and that ruling quietly affects people with old drug convictions, including cannabis felonies. Now, what's unresolved, at least at first glance, is how a Reconstruction-era agreement can override a modern state constitution. That tension sits at the center of this story, and we'll come back to it, because that's where the legal consequence becomes clear. Here's the counterintuitive legal fact or misconception. There's a common assumption that voting rights restoration in Virginia is purely a matter of executive grace, that it's something the governor gives, or withholds, at discretion. But that assumption doesn't fully hold under federal law. Or rather, it doesn't hold once you account for the conditions Virginia agreed to in order to re-enter Congress in the 19th century. That matters, because that matters legally. Most people believe felony disenfranchisement is settled law. It's written into the Virginia Constitution, it's been enforced for generations, and courts historically deferred to states on voting qualifications. But here's the problem. That belief quietly ignores a binding federal agreement that predates the modern Virginia Constitution. And once you notice that, well, the entire framework starts to shift. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. Now, today's discussion is not about cannabis legalization. It's not about expungement, sentencing reform, or political advocacy. This is a legal analysis, specifically, how a Reconstruction-era civil rights law is being used to challenge Virginia's automatic felony disenfranchisement system, and why cannabis convictions are part of the affected population. We're staying firmly in compliance territory here: constitutional law, federal statutes, and enforcement consequences. And as we go, keep in mind the issue I raised at the beginning, because the resolution depends on how federal supremacy actually works in this context. Here's the context. After the Civil War, former Confederate states were not automatically welcomed back into the Union. Congress imposed conditions, very explicit ones, before readmission. Virginia, like other states, had to ratify the 14th Amendment and formally agree that it would not enact or enforce laws that violated federal civil rights protections. Congress didn't rely on trust. It passed readmission acts in 1870 that made these commitments binding. Over time, though, Virginia developed a constitutional system that automatically stripped voting rights from anyone convicted of a felony. Restoration became individualized, discretionary, and executive-driven. That system persisted for more than a century. And because drug enforcement expanded dramatically during the War on Drugs, cannabis convictions were swept into that framework, even though the original civil rights agreements had nothing to do with drugs at all. Here's the legal explanation. Now, let's slow this down, because this is where the law gets technical. The federal ruling out of Richmond focused on whether Virginia's automatic felony disenfranchisement violates the conditions under which the state was readmitted to Congress. Under the Supremacy Clause, those conditions, passed by Congress, carry federal authority. The judge's reasoning wasn't that Virginia can never disenfranchise. It was that a blanket, automatic system, applied without individualized review, conflicts with federal civil rights protections agreed to during Reconstruction. Let me rephrase that. Virginia treated voting as a privilege that could be permanently removed. Federal law treats voting as a right that can only be restricted within narrow, justified limits. That distinction, privilege versus right, is where everything turns. How enforcement works. So how does this actually get enforced? Well, enforcement doesn't start with cannabis. It starts with voting access. Civil rights challenges are brought in federal court. Judges examine whether state practices conflict with federal obligations. Lab reports, criminal classifications, or modern policy shifts, those don't control the analysis. What controls is whether the state system creates a broad civil rights violation. As I said, what controls is whether the state system creates a broad civil rights violation. And once that threshold is crossed, enforcement isn't discretionary anymore. Federal law overrides state practice. This is where earlier assumptions start to fail, and we're getting close to why cannabis felonies matter here. Who this affects. Consumers are affected first, people who completed sentences years ago but remain barred from civic participation. Retailers and business owners are affected indirectly, because voting shapes zoning, licensing, and enforcement priorities. Local governments are affected because voter composition influences cannabis policy debates, especially in places like Norfolk and Hampton Roads. And the medical cannabis framework is affected because patient advocacy and regulatory oversight depend on civic access. Each of these groups intersects with voting rights differently, but the legal route is the same. Why this matters? This matters for public safety because civic exclusion erodes trust in legal systems. It matters for regulatory clarity because inconsistent enforcement invites litigation. It matters for legal and financial risk because state systems that violate federal law eventually face correction, often expensively. And it matters for long-term policy because, well, policy is written by voters. And voters were removed by policy. Here's a scenario. Now let's return to the issue I mentioned at the beginning. Imagine a Norfolk resident convicted of felony cannabis possession in the early 2000s. Sentence completed. No further offenses. Voting rights never restored. Under Virginia's system, that's lawful, on paper. But under the Reconstruction Agreement, the question becomes whether permanent, automatic disenfranchisement is permissible. This is where that issue becomes clear. The federal court says no, because Virginia agreed, in writing, not to do this. Contrast that with an individualized review system. Same conviction. Same sentence. But restoration evaluated case by case. That distinction changes everything legally. What to watch next? Watch how Virginia responds. Legislative reform and constitutional revision are not the same thing, and federal oversight doesn't disappear quietly. Or you can check out some of our recent videos on Virginia Beach Cannabis Policy and Legalization Timeline, the Virginia Cannabis Retail Market Update for Norfolk 2026, and another more popular video on how cannabis law in Virginia just changed. Here's a question. If voting is a right under federal law, how should states reconcile punishment with permanent civic exclusion? So here's the takeaway. This ruling didn't come from modern politics, it came from Reconstruction. And while cannabis wasn't the target, cannabis felonies were caught in the system. If this kind of Virginia-specific legal analysis matters to you, like the video, subscribe, and join the Norfolk City Cannabis Community for deeper discussion, always focused on compliance, law, and governance.